Hello, my name's Sian Darlington and I'm a business crime and regulatory solicitor at Gunner Cook in Manchester. This is my second in the Don't Let It Be You series of vlogs designed to provide information to businesses as to how the criminal law may impact upon them and to give some practical tips to prevent that from happening. In this session I'm going to talk about health and safety law, which is topical at the moment as businesses prepare to return to the workplace following the easing of the lockdown measures. So what does the law say? Well, under the Health and Safety at Work Act, employers must do everything that is reasonably practicable to safeguard not only their employees but anyone affected by the business's operations. So in the case of an office, duty will be owed not only to staff members but to those who attend at the offices for meetings, to make deliveries, etc. If you're a sole trader with no employees, you will owe a duty only to the extent that the operation of your business impacts upon others. What does reasonably practicable mean? Well, it's not defined in the law, but it basically involves weighing up the risk of harm against the cost of preventing that risk in terms of money or time or trouble. Much will depend upon the size of the business and the nature of the operations. It's not an all or nothing principle, so if you consider that something's disproportionate, you need to consider whether there are easier or more proportionate steps that can be taken. So that's the duty. What other obligations are there? Well, under regulations, all employers must undertake a risk assessment, and where there are 5 or more employees, that needs to be in writing. And that really involves identifying the risks, who might be affected, the likely harm that would be caused, and the steps to be taken to prevent or mitigate against those risks. In the current time, when weighing up the risk of coronavirus, the things to consider are the facilities, so things like hand washing, water, places to prepare food, the environment, so is the office adequately ventilated, etc., and the workspace itself in terms of how to mitigate against the risks posed by the coronavirus. The risk assessment needs to be reviewed on a regular basis or in the change of circumstances, which is exactly why businesses are reviewing their risk assessments or creating new ones at the present time. There are other regulations which deal with specific issues such as display screen equipment, manual handling, PPE, fire safety, the list goes on. If those regulations affect your business, you need to be familiar with them. So why is it so important to comply with the health and safety law? Well, not only do most employers not want to put their employees at risk of harm, but breach of the law is a criminal offence and the consequences can be severe. In serious cases, not only the organisation but its senior officials run the risk of prosecution. Breach of the regulations can result in a fine, and in serious cases, not only can fines be astronomical, but the senior officials can face the risk of imprisonment. But it's not just the risk of prosecution. The Health and Safety Executive, which is the organisation that enforces the law, has wide powers of investigation and inspection and a range of measures open to it. It can give formal advice, issue a caution, or issue enforcement or prohibition notices, and there can be financial consequences even without a prosecution, as the HSE has a power to impose a fee for intervention where it will basically charge £157 an hour for the time it's spent identifying the breach and helping you to put that right. So that's the law and the consequences. I've got 5 tips to prevent it from happening to you. Firstly, appoint a competent person to be in charge of health and safety. That might be the business owner, a member of staff, or an external consultant, although that's by no means necessary. It really depends on the nature of your business. Secondly, record everything in writing. Not only the risk assessment, but your thought processes for the decision making. The HSE are likely to be a lot more sympathetic if you can show, for example, that you considered a particular risk or control but discounted it, than if you can't show that you considered it at all. Thirdly, communication is key. Encourage a culture of openness so that staff can raise with you their thoughts and their concerns so that matters can be dealt with as quickly as possible. At the current time, it's also worth getting information from staff members as to any particular vulnerabilities that they have whether they have underlying health conditions, if they're living with somebody that's shielding, or if they're just extremely anxious about the return to work, as not only will that really help you in terms of your risk assessment, but will hopefully create a happier workforce. Fourthly, if an employee contracts COVID, you may have an obligation to report that to the HSE if there's reasonable evidence that that happened in the workplace, and that's an obligation under RIDDOR. There is guidance on it on the Health and Safety Executive's website. It's really worth looking at that, as that's something that could happen in any business. And finally, keep up to date. Ensure that you're familiar with the guidance. There's lots of guidance at the moment, both on the government's website and the Health and Safety Executive website, and it is changed regularly, so make sure that you are looking at that on a regular basis. I hope that helps. If you want to chat about anything or have any questions, please feel free to contact me. Otherwise, I will be back soon with my next instalment, so take care, and remember, don't let it be you.